in terms of moving to evidence-based practices and its implication for state judiciaries. The first question we'd like to talk about is, what are some examples of where evidence-based principles have been adapted in your own or adopted in your own jurisdiction? And I'd like to hear first, if she would, from Judge Maurer.
Thank you, Justice Durham. Yes, I'm Judge Maurer in Multnomah County, and we have a very collaborative system here among all of the stakeholders, which has benefited us in terms of the evidence-based practices throughout the system. Little examples that I would like to touch on, given my 2-minute response time, are beginning with the pre-trial release decision. When an offender comes into the jail after an arrest, we have implemented an instrument which has been validated in terms of deciding which offenders will stay in custody and which offenders will be released back into the community while they await their arraignment. That is a significant undertaking, and it has the effect of producing the results that the community wants in terms of public safety, and also increasing the chance of the offender being able to resume life in the community and not have the disruptions that we know lead later to continued criminal behavior. Another example I would like to cite to is the approach that our Department of Community Justice, and I would say that broadly is the Probation and Parole Department. The Community Corrections has collaborated a great deal with the courts, and they now do a risk and need assessment. They use structured sanctions. The legislature provided for that several years ago so that there can be a swift and sure response when there is an offender who is on probation and has not been in compliance, but it may not warrant bringing it back before the judge. We also have release hearings, which are post-arraignment, where the judge is involved and needs data to be offender-specific, so that the judge can be well informed before making a release decision. We are fortunate because we have a data warehouse here which tracks individuals throughout their career by person, and it is one data system that collects data to be used collectively by all of our partners, the DA's office, the sheriff, the courts, the city police agencies, and so forth. We have improved our information that the judge is given whenever a pre-sentence report is ordered. We now have the individuals who are writing the pre-sentence report look at what works and make a recommendation to the court, which takes into account the programs that may be available in the community, so that the judge is well educated as to which program would be most suited for that particular offender. I have more to say, but given that I have my 2-minute allotment, I'm going to turn it over now, Justice Durham, to you, and then maybe I can speak at a later time.
I appreciate that. Actually, I would, before we move to the correction side, I would appreciate it if perhaps you could clarify what the definition of an intermediate sanction is. That might be a new piece of vocabulary to some people.
Oh, sure. When an individual is placed on probation, historically, the probation officer monitored that individual to see whether the individual was in compliance with the conditions of probation that had been set by the judge. The problem was that some of the offenders were in violation of their probation, and by the time a report was written, an arrest was made, the offender was brought before the court, enough time had elapsed that there wasn't a sanction that was appropriate immediately to that offender's violation. And so a different system was embarked upon several years ago. And now the offender is connected to the probation officer, is told by the probation officer that the probation officer is envisioning a sanction. It could include community service. It could include our day reporting center. It could include jail. And the offender has an opportunity to consent to that sanction or to demand a probation violation hearing. If the offender consents, which most do, the sanction is immediately imposed, and therefore there's a direct correlation between the violation and the sanction. And we know that the immediacy of the sanction in connection to the violation is a crucial part of reforming behavior.
Excellent. Thank you for that clarification. Let's move then to the correction side and turn to Chairman McVeigh.
Yes, thank you. In Pennsylvania, I need to say that we do have a criminal justice environment that's supportive of pursuing, in fact, even demanding that we challenge ourselves in sentencing, in corrections, and community supervision to be an effective system. We recently had legislation in the Commonwealth that created a recidivism risk reduction system in which offenders have an alternative minimum sentence that is lower than the regular minimum sentence. If the offender completes all programming, has reduced risk, the offender then is under a presumptive system of parole and is able to be released earlier. And we've targeted our less serious type of risk population for that program. We have started that 2 years ago, and it's growing in success to target the less serious offender, to move them more quickly through the system and target their criminogenic needs and then move them on to a period of supervision. We also have new legislation that is pending that was recently drafted, which will introduce and formalize the concept of considering risk at the time of sentencing, and that is something that I think judges in the Commonwealth independently do as a natural part of sentencing, but it is not formalized as a part of sentencing practice. Internally in our parole system in the Commonwealth, we conducted a massive kind of gap analysis challenging what we do versus what we should do that's evidence-based. And we have now introduced within our own parole system evidence-based parole decision-making in our sentencing guideline that incorporates actuarial risk information. We use the risk principle to apply that helps guide us in our guidelines. We've introduced the concept of targeting our interventions and really differentially managing our lower risk from our mid to high risk offenders at the point of reentry and supervision. And very importantly, and I know I'm running out of time, but very importantly, we are using the risk principle as we consider the all present for all states, the problem of our technical parole violators. And we're really focusing on managing them in a very distinct way to elongate the period of safe and effective supervision in the community and truly only return those into the prison system who are assaultive, who pose a true imminent risk to public safety.
Thank you. I wonder if I could just briefly follow up. So many of our participants today come from jurisdictions where there's minimum mandatory sentencing. Do you have that in Pennsylvania, and how does that affect the way you're trying to work with evidence-based practices?
We do have mandatory minimum sentencing, and we do find that, of course, when you're applying evidence-based practices and you're applying risk, it is in conflict with mandatory minimum sentencing for a portion of the time where the sentence should be longer or shorter. And we have that mandatory minimum. So that is an issue. We have found ways to kind of work around that with other population, other offender categories that are not subject to it. But it does pose a challenge if we're truly applying the risk principle to the populations.
Thank you. Let's turn now to Mr. Bouch.
Thank you, Chief Justice. In Napa County is a fairly small county, couple 100,000 people, 8-judge court. And back in 2004, we had gone through a major redesign of all of our civil, criminal, juvenile case flow models to make sure that we were doing those things that are expressed as best practices in court case flow. And we got very good at it. But then at the end of these cases, we had come to the point where we are looking at the and saying, we are doing things right, but are we doing the right things? Because at the end of both the criminal and civil process, we hit that divide between legal, procedural fairness and the social science psychology of corrections. And so we turned to our probation officer and said, we need to find out what works for our sentencing, because giving sentences without seeing if they work seems to be kind of silly. And our probation officer went out and found, did a lot of research on evidence-based practices, and came back with a plan for training her staff on EBP, doing training the staff on motivational interviewing techniques, cognitive behavior group leadership, and implementing a risk assessment instrument that the staff were trained on, so that we could start looking at how does she deploy her workforce with the caseload that she has to get the best return on that. And then how do we get the rest of our criminal justice partners to come together to put the evidence-based practices inside the entire justice system here in this county. You know, and the analogy we used was that this is like a hospital where we're trying to make people better. And if the pharmacy and radiology and outpatients and the emergency and the operating room don't talk to each other and don't work on the same idea of making the patients better, we will fail. And we came to the Board of Supervisors and talked about the 2% solution. If they can invest 2% of the money that's spent in the criminal justice community here, in this innovation, we can make this system better. And we broadened it over time to the board invested $1 million in the year when they really didn't have the money. Our health and human services, alcohol and drug programs, and the mental health programs have all adopted evidence-based practices. Our corrections department is using evidence-based practices in redesigning their classification system and redesigning their housing setup so that participants who are in custody can participate in the community corrections center we've set up to do the programming. And both the prosecution, defense, and public defender's office have all been trained in the basic concepts of evidence-based practices. So now we've got congruity in the way Napa County approaches this whole system of criminal justice.
Thank you. I wonder if I might follow up. It sounds as if you have astonishing convergence of all the elements of your system in adopting this approach. How did you make the case?
Well, you know, you always find some compelling crisis to make people listen. And when we went through our redesign of our caseflow model, it shortened the time frame for filing to disposition, and it put a temporary surge of folks coming into the county jail. And the county fathers were a little concerned about the federal lawsuit and supervision and the need for building a new $40 million jail. And so the idea of doing evidence-based practices and only keeping people incarcerated that need to be incarcerated seemed to be a really good idea for them. And so we seized on the moment to educate the Board of Supervisors and the rest of the criminal justice community around these evidence-based practices.
Thank you. That's another illustration of the precept that a good crisis is a terrible thing to waste.
That's right. You never waste a good crisis.
That's right. Let's thank you so much for all of those responses. We're going to move to another polling question for our audience. We'd like to ask the members of the seminar whether in your own jurisdictions you are currently utilizing evidence-based practices or principles. So while you're responding to that, we will get ready to talk about our next subject, which builds on the last responses of Mr. Bouch, and that will be talking about how we make the case for shifting entire corrections and sentencing systems from traditional-based principles to evidence-based principles. It appears that a significant majority of our participants, almost 75%, are currently utilizing evidence-based practices and principles, which suggests, I think, to our panelists that the specific things that are working and not working for you will be very helpful. And I'm pleased to note that 7% of the respondents responded by saying not yet, which means they're hoping to move in that direction. So let's talk a little bit more about how you make the shift. Where you start, is there a universal starting place, or do you have to assess your own system to see where there might be an opening? Mr. Bouch, why don't we come back to you on that?
I think the key to it is leadership, and you touched on it early. The court is at a very central position and has a great ability to bring people to the table to discuss issues like this. And an overwhelming collaboration can be forged between the funding authority and the court in particular. Because if those two entities lead this project, it has a very high likelihood of success. And the leadership comes to envisioning a new way of approaching the criminal justice system, as you mentioned earlier. It's a different way of looking at the people in the system. It realizes that all parts of the system are working toward a single goal, and that goal is really community building, because everyone, or virtually everyone that goes through our system eventually comes back into community. And our goal is to make the community safer, stronger, and more productive. The other thing that those two have in common is they have the unique ability to network and to engage other sectors of the criminal justice system to action. And so between that leadership, and that leadership means...
Could you give us I'm sorry to interrupt.
No,
could you give us
fine.
a specific example of how you set up such a networking opportunity?
Well, many communities, criminal justice communities, have a criminal justice commission or task force or working group where the members of the criminal justice committee get together and talk, do problem solving. And those things so frequently deteriorate into micromanaging very small, unimportant pieces of the system. And being able to take that and bring to the table this new conceptual framework and educate that community, that group of leaders around this idea of evidence-based practices is crucial to success. And so getting to the table and inspiring that new view of what we're supposed to be doing here, and then having the funding authority there to help align those parts of the system that may not be particularly willing to go through the pain of change is really a powerful combination between the court and the funding authority.
Thank you very much. Let's turn to Chairman McVeigh. One suspects that some of our participants may wonder if this is much easier on a local or county level as opposed to a state level and from the corrections perspective.
Thank you. I think in some ways it may be easier on a smaller local level than a state level. I will say the benefit at the state level is oftentimes we're funded maybe a little bit more robustly and have that opportunity. In terms of how a system can shift to using evidence-based principles to predicate policy decision, I think we have to focus on several levels, and I think fundamental to a shift is to really examine what is your core mission, what is your correctional objective, what is your criminal justice objective, and challenge ourselves to answer, are we achieving it? Are we achieving what we set out to achieve? And if we are not, then we have to think about how can we do it better. So I think you have a philosophic shift in terms of looking at evidence-based practices. I think that from an operational perspective, part of changing policy is then supporting that policy change through a tremendous amount of ongoing professional development, education. I think creating a pilot or demonstration project is extremely helpful because most of us are kind of prove-it-to-me practitioners. You know, we want to see how the new practices, what the outcomes are. I think focusing on becoming more outcome-oriented, and then I think the almighty dollar comes into play. We cannot keep building more prisons. And I think when we look at the dollar savings reinvested in more effective practices, I think that speaks volumes and begins to sell itself. So at the operational level, it's about changing, it's about education, it's about professional development, it's about challenging ourselves in terms of are we achieving our core mission, and then it's about looking at the cost savings that can be derived from the enhanced practices.
Thank you very much. One of the things that we haven't talked about yet, but which is very important to the way in which we operate, is the organizations affiliated with community justice out there in the community. And I would like to hear from first Judge Maurer and then Chairman McVeigh on their thoughts as to how evidence-based sentencing theory and practice has affected the way they operate, first from the courts, second from corrections, with other community justice organizations. Judge Maurer.
Thank you. I would say that I would like to echo the comments that have already been made. Judges have obviously a great interest in making certain that the offenders who come before the judges, over whom the judge has some discretion. So I am taking out all of the mandatory minimum sentencings that come before us, and I'm taking out to a degree some of the cases that come before us as a result of a plea bargain. And I am directing my comments to those cases in which the offender is going to be placed on probation, because under the sentencing guidelines that is the presumptive sentence. And we want to make certain that we have the best information about that offender before we impose the sentence. So we have worked closely, very closely, with our Department of Community Justice, which is our probation department, to provide us with that information. And so it is to that end that they have embraced the tool that I described earlier, which we use for our pretrial release decisions. That particular group of people is funded through the courts, but they are supplied by the individuals who are assigned to the probation department, and we work very closely with them to make sure that we don't have a situation where there is the subjective determination by that officer as to whether an individual should be released or detained in custody, because we have found, of course, as everywhere else has found, I think, that although we all believe that our subjective reaction to another individual is the very best and ideal assessment of that individual, we know that that is not true. And so we have now developed tools, and we have worked closely with our community justice partners to ensure that the tools are being followed, the assessments are being made based on objective criteria. That pretrial release decision is only one example. We also, as I say, have asked our community justice partners to present to the court better information at the time of the probation violation hearing that may occur, for example. And now our probation department provides to the court the description of the criminogenic factors which are at play in that particular offender's life. Prior to that, we had probation reports that simply described the history of the offender, that is the criminal history, some social history, and then the probation officer's recommendation without an identification of criminogenic factors. We've also worked hard with the Department of Community Justice to learn motivational interviewing techniques, and they have readily embraced that. We have a good relationship in that they also use a risk and needs assessment tool and have for some period of time, so that we know a great deal about where that offender falls in terms of both the risk and the needs. It has not been particularly difficult because we have had wonderful leaders of our Department of Community Justice. And as Mr. Bouch was saying, we have a local public safety council that meets regularly once a month, and all of the partners in the system are represented, and we have a very robust discussion. We are in constant communication with one another, and as a result, although there are areas in which some of our partners view things perhaps differently from the way other partners view things, we have a collaborative group. And I think we've been fairly successful by having both judicial leadership and leadership from the probation department working closely together. We also have a fairly collaborative working relationship with our district attorney and our sheriff.
That's a remarkable collaboration. I wonder if you could share with us the name of the pretrial instrument, or I'm sorry, yes, the pretrial instrument that you use, the assessment instrument, and who actually administers that.
The name of it, I tend to just call it the pretrial instrument, and I can obtain that name. But the individuals who administer it and employ it, as I said, are probation officers. So they have training in that department, but they are working for the courts. And so those are the individuals who actually use it on a daily basis. So they are part of the court's recog staff. And if you'll hang on just 1 minute, I'll grab a copy of one of the instruments.
Okay, thank you very much.
I have it right here.
That was very impressive. Thank you. What's it called? Was it
well, of course, I grabbed it, and all that I see here at the top is the form that is filed in our court, and it's the release form. I can very quickly access the instrument, and I will put my button on mute and go and get that while you...
Okay, and I guess the question that our participants might be interested in is whether you developed it yourself or whether you modeled it on a more widely used instrument from around the country.
We modeled it on a more widely used instrument, and we tweaked it ourselves. Okay, so I'll go and obtain it right now, and then I'll come right back.
Thank you. And we'll turn now to Chairman McVeigh to address this same question about, which you already have addressed in part, but you may have more to say about other community justice organizations.
Yeah, I think this is a very important aspect because this question kind of brings it all together for me. And so how have evidence-based practices affected the interaction? And the way it has affected it is it creates more consistency, more coherency, and more effectiveness. And what I mean by that is when you have evidence-based sentencing, it creates, I believe, an expectation for the interaction with the offender of the other criminal justice organizations that they're here to reduce risk, because the sentencing is predicated in part on assessing the type of risk and the seriousness of risk and the level of risk. And so it creates a burden of responsibility for those other organizations to also be evidence-based. I think it approaches, as we look at an offender and the continuum of management of the offender, the coherency is it reduces the risk, the conflict between organizations. For example, I'm often asked as a paroling authority, why in the world did you parole that bad guy who did a horrendous crime? Well, because his risk level is about 0. He's an elderly person that has a reduced risk of reoffending. The type of offense was one that is a low risk, and there's no reason not to parole him even though he did a heinous crime. When you introduce evidence-based decision-making in sentencing, then the sentencing component has already accounted for that risk, and the question of why you're paroling them or not really then kind of falls to the wayside. So all components of our system are looking at the offender basically through the same set of lenses with the same expectation and concerns and approaches for management.
Thank you very much.
I'm back if you want me to follow up a little bit, Justice Durham.
Sure, that would be helpful, and we also can add information on the instrument question to our frequently asked questions feature on the webinar. So.
All right, thanks. Well, when we developed this, which was about in 2002, we developed a system based on our scan or evaluation of other tools that were used in other jurisdictions. But then at the end, we collaborated with our partners to build our own tool, and that's the reason I kept referring to it as the Multnomah County Pretrial Release Tool. And that's what it is essentially. We'd be happy to share it with anyone who'd be interested because it has now been, as I say, validated recently. And so we know that it does what we intended for it to do.
Excellent. Thank you for that update.
Sure.
And thanks to everyone for their thoughts on this particular question. We'd like now to get to what we hope is the meat of the seminar in some respects, and that's a discussion with our participants in terms of responding to the questions that they have. I just wanted to note that there are 39 states and the District of Columbia and Ottawa, Canada represented in terms of audience participants. So quite a broad cross-section of American and Canadian jurisdictions. I'm going to ask Kate to narrate the questions. We've been collecting them as they've been submitted. We'll try to answer as many as possible in the remaining time for today's program. So I'll turn it over to Kate to read the first question.
Thank you, Chief Justice Durham. We have had several questions about that pretrial risk tool that Judge Morrow was discussing, and so we'll make sure to include additional information on that on the FAQ sheet, as you mentioned. Some folks are wondering how evidence-based practices are utilized in the context of plea negotiations.
Excellent
this
question.
is Judge Maurer. I'd like to take a run at that if that is acceptable.
Please.
All right. I wanted to speak to that very issue because that is one of the most difficult points in the system to introduce evidence-based practices. We have not, frankly, made tremendous strides in that area, but we are working on it. And so the fact that we do have a collaborative relationship with the District Attorney's Office and the Defense Bar assists us in that regard. However, it is, as the other panelists have said, a process of education, education, education. And because sentencing is also always a political process, it is one of those areas which is difficult to address quickly. So I can only say that we are working on it. We have introduced the concept, obviously, of evidence-based practices to our district attorney's office and our defense attorneys. And we do have a very progressive district attorney here in Multnomah County, which helps. And that's an area that we are now turning our attention to.
Thank you. Mr. Bouch, have you addressed this in Napa County? I'm not getting a response from Mr. Bouch, so maybe we'll move to the next question. I'll ask Kate to read the next question.
Absolutely. Folks are wondering about the collaborative case management that was talked about and how, well, whether or not other states are using that in conjunction with evidence-based sentencing.
Thank you. And I do need Mr. Bouch. Are you there, Stephen? I'm wondering if he's accidentally put his telephone on mute. In light of that, let me ask Judge Maurer whether you have addressed case management in this context, and or if you're aware of other states which are working on this.
Now, when we're talking about case management, are we describing the period of time after an individual has been sentenced? I'm assuming that is what is meant by case management, but I'm not certain.
No, I'm not certain either, and I'm not sure that the question clarifies.
All right.
This is Chairman McVeigh. I could take a stab at it.
Right.
Please.
Collaborative case management in the Commonwealth means that as we look at an offender, we work with entities who specialize in their care. For example, as we have an offender getting ready to leave our prison system, returning to the community, then we're going to be assessing that offender jointly with the psychologist in the prison system, with our mental health caseworker in our parole system, and with the local mental health case manager, so that we share information, we share actual information, and then we jointly create a plan of care for the offender. Another aspect of joint case management is an innovation that we use in the Commonwealth called Reentry Court Program, in which we have paroling offenders, and I'm hoping we're going to be expanding it to probation cases also, that actually we have a parole board member sitting in the court co-equally with the judge, and all of the local community resources, whether it's our jail, our mental health, our substance abuse, our housing authority, to work to manage those parole cases and create, through actuarial assessments and assessment of their criminogenic needs, again, what their supervision plan should be. And the local authorities work jointly with parole and with the court to ensure that those support services, treatment services are met. Oftentimes the offender has been sentenced from that court, so they're kind of returning back to that court, and that offender is jointly accountable to the court and to the jurisdiction that it's under currently, under parole. And it's proven to be really quite a successful type of specialty court.
Well, and your mention of specialty courts is particularly appropriate because, of course, I think that one of the things that has made possible the emerging commitment to evidence-based practices are the specialty problem-solving courts that the state courts have been introducing in the area of drug courts, mental health courts, and so on, because those have introduced collaborative case management in exactly the same model you described from Pennsylvania on the correction side, and they also gave rise to the need for really accurate outcome measurement and a focus on outcome. So those are very good models, and interestingly, I don't believe there is a state in the United States that is not engaging in some form of problem-solving courts, and they are using collaborative case management techniques in that context. Did you have anything more, Judge Maurer?
I do. Thank you for that, Chief Justice. I would indicate that one new collaboration that we have begun here in Multnomah County bears mentioning, I think, and that is how to deal with the offenders who intersect with the mental health community and also have found themselves involved in the criminal justice system. Typically, we have seen that offenders who come into our jails on fairly low-level but chronic offenses, who suffer from a mental health disease or defect, spend many, many days in custody, and particularly if those offenders are unable to aid and assist in their own defense, their defense attorney is put in the untenable position of either trying to have their client enter a plea quickly so that they can take advantage of a minimal plea bargain offer, perhaps 2 days in jail, and the competing need to make sure their client can aid and assist in that plea and to have their client assessed. The assessment takes such a long time that we now have a population of people who sit in the jail not because they wouldn't otherwise be released following perhaps a plea and sentence, but because they're unable to aid and assist in their own defense. And so we have developed a recent program which involves a collaborative case management system described by Chairman McVeigh, in which we have partnered with the Department of Human Services to move those individuals out of the jail as quickly as possible into some placement which will protect the community and also protect that individual pending an evaluation on their competency.
Right, right. Thank you very much. Let me ask
Justice Durham?
Oh,
can you hear
good.
me
We're
now?
glad to have you, Mr. Bass. We can hear you.
Operator error. My finger's not working today. I did want to make a comment about the problem of interjecting the plea negotiation process with the issues
Certainly.
of evidence-based practices. And it's one that we wrestled with early, and as a court we decided that the evidence-based practices and the programming that are being provided through our Community Correction Center are a probation tool. And the judges said, we are not going to plea negotiate around the program participation. We will put people on probation or not, as with prison sentence or not, whatever it may be, according to how we see the case best, how it best plays out. But at the probation department and the mental health, the alcohol and drug folks have both collaborated extensively in providing to us at the sentencing report the risk assessment instruments for both alcohol and drugs and for the criminogenic need. That information is shared with the attorneys, but the judges won't, the entry into the program or not is something that's the discretion of the probation officer. And the probation officer does it based on the severity of the risk, and they decide who gets into the program and who doesn't based on severity of risk.
And how have prosecutors responded to this sort of barrier to the exercise of their discretion on plea bargains?
Prosecutors, it took some education, and that's where when I talk about education, it means down to the field level.
Right.
We've put a lot of time into not only talking about this at the policy level and at the Criminal Justice Council level. We brought that kind of education and training down to the line prosecutor so they could see where this plays and how it fits in the system. And
right.
I think that education made a huge difference in their acceptance of it and their willingness to leave it in the hands of the people who are charged with making those programs work.
Thank you very much for those thoughts. I think we could move to another question, Kate, if you have one.
We have lots more. Thank you. And we just wanted to let folks know that we are, in fact, doing a whole webinar in this series on pretrial, which will include discussions on assessment as well. So we welcome you guys to join us that as well. It is the June webinar, and we will be sending out schedule information to everyone who has attended. The next question, Chief Justice Durham, is around models of comprehensive legislation, and the audience would like to know if the panelists can discuss any models of comprehensive legislation to implement evidence-based practice on a statewide level.
I'm going to turn that one over to volunteers. Perhaps Chairman McVeigh might have the best perspective dealing from the state level as to what's happening in her state, but also around the country. I don't know whether the Uniform Law Commission has addressed this or whether anyone has developed a model yet.
Yes, thank you. I briefly mentioned in a prior answer to a panel question regarding the Commonwealth's approach to looking at lower risk offenders and sentencing them accordingly. And as I mentioned, we've actually created for that population and we excluded offenders who are violent offenders who have had prior violence in their history. So we're targeting primarily nonviolent property offenders, drug offenders, who are now subject to, the court is required to actually establish 2 minimum sentences. We have a system in Pennsylvania of a minimum and a maximum date. And so those offenders who fit that criteria receive an alternate lower minimum sentence so that they have something to work for. They have an incentive to complete their programming, develop their reentry process, and if they accomplish all of that successfully, then they are under a presumptive model of parole. We can still refuse them parole, but we predicate our parole basically on whether risk has been satisfactorily reduced, and if it has, they're automatically paroled. We actually then carry that through, and I didn't mention this, to how we supervise those offenders. For those offenders who then are out on parole, if they satisfactorily complete 1 year of parole supervision, conform to the requirements and conditions of parole, then they are placed on an administrative caseload, which also is an evidence-based strategy to differentiate our management and to target our resources to the mid to high-risk offender. So these lower-risk, less serious property offenders that are under basically an annual reporting scheme. We have not had this new system in place long enough to acquire outcome data. That will be coming, we'll start acquiring that in a year from now. But our expectation is that it's working and it's wisely using resources. We also have a system of intermediate punishment sentencing that was introduced several years ago in the Commonwealth, where offenders can be sentenced to a flat 2-year sentence in which they go to the Department of Corrections. These are primarily drug offenders. They go through a 6-month therapeutic community. They're automatically then transitioned to the community and they finish their 2-year sentence. So this entire sentence is focused on addressing their primary criminogenic factors.
Thank you. Let me ask if you could make the citations available to staff. I assume that we could post those as a link on our frequently asked questions as well, so people could follow up on the Pennsylvania system.
Absolutely. I will also reference the pending legislation that we have for formally introducing risk at the point of sentencing.
Excellent. Do either of the other panelists know of any models that would be available for people interested in comprehensive legislation?
This is Judge Maurer. I can provide the information that is now required statewide of all writers who are preparing a pre-sentence report to the judge prior to sentencing, and what is required to be included in that report with respect to risk and criminogenic factors. So I can obtain that information and provide it so that it would be a link to the audience.
Thank you. Thank you very much.
Sure. And Justice Durham, this is Steve Bouch. California is at the beginning stages of this process. About a year ago, with the assistance of Judge Warren, California was able to cobble together some funding for pilot projects relating to risk assessments and evidence-based practices in sentencing. Because we were already quite a ways down that road, Napa was selected as one of the 2 pilot courts, San Francisco is the other, and I think the long-term goal for California is to come up with exactly that, some type of a statewide blueprint.
Excellent. Thank you. Kate, do you have another question?
Thank you, Chief Justice Durham. One audience member writes, corrections culture has historically been security-minded and is slowly moving toward rehabilitation. While each of the panelists is clearly forward-thinking, do the panelists feel that the overall judicial culture is excited to move in the direction of evidence-based principles? And how can we get our judges in our jurisdictions to be more engaged?
Thank you. I actually would like to take a crack at that before turning it over to both Judge Maurer and Mr. Bouch, to say that we are in the early stages in our state of looking at evidence-based practices, and I can attest to the fact that our trial judges, there is an old guard that is resistant to change in whatever form it takes, but that the success of the problem-solving approach in the area of drug-related offenders or drug-addicted offenders has really captured the imagination of the community at large, of the legislature, and of many of our trial judges. And I think there's a lot to be said for continuing down the educational road to illustrate to the members of our courts what it means to the revolving door that they see in criminal justice practices when they actually can start asking questions about what works and why. And once you've made that case, I am very optimistic about significant change. What do you see, Judge Maurer?
I see a tremendous shift in Multnomah County among the judges toward evidence-based practices. They are at the forefront of that. I don't know that that is universally true throughout Oregon, however. We have probably, because we were the second drug court in the country, been accustomed to the therapeutic approach, problem-solving approach that those courts tend to utilize. And as a result of that, we have expanded in Multnomah County from our initial drug court, which is still operating. It began in the early 1990s, and into other areas. One area, as all people know, that is of grave concern is that area involving repeat drunk drivers. And so we have for many years had a driving while intoxicated intensive supervision court, which is highly managed or directly managed by a judge, in which the offender is given the opportunity to participate and to report to the judge frequently, initially, in exchange for a reduced jail sentence, if you will. And the district attorney's office was introduced to that concept and was an integral part of that many years ago, as was the defense bar and our community justice partners. And so that court has been in operation a long time, and the therapeutic model has been a source of interest to all judges. And so we now are starting a brand new model court for repeat property offenders, which is almost up and running. In fact, it is up and running, but it still needs to be addressed in a more complete way because we don't have enough people in that court. We also have a mental health court and a domestic violence court. I think many jurisdictions have these courts, but when you begin to have a certain number of courts, what happens is the rest of the judges begin to see how those courts work, and then they adopt those models themselves. And we're approaching DUI sentencings in a new way as well, so that we can get more sentences that are based on evidence rather than just the plea bargain.
Thank you. Which suggests that one way to build the support and enthusiasm may be to focus attention on existing and emerging and developing problem-solving approaches in specialized areas, and then generalizing it in the criminal system. Mr. Bouch, anything to add, or then Chairman McVeigh from...
I would like to simply say that our experience here has been extraordinary. This shift to evidence-based practices has done more to re-energize the probation workforce and staff than anything I've ever seen in all my years of working around probation people. It's incredible that the source of most of the conflict, I think, in terms of probation staff, is the perennial divide between peace officer status and non-peace officer status, and the move for the field to move to a more law enforcement view was driven by those collateral issues around pension and retirement and that type of thing. I think there's a new group of probation officers coming in who really want to see the system make a difference in people's lives, and those people are blossoming under this, and the old guard is not sticking around for it. They're largely leaving the system.
Thank you. I'm curious, Chairman McVeigh, as someone who sits outside the courts, what do you think it's going to take to help build enthusiasm for this movement within the courts themselves?
Well, I think being close to age 60 and being in this business for 38 years now, I'm still ever the optimist. And what I mean by that is I think all of us have gotten into this business because we want to make a difference, whether it's a probation officer or an attorney, defense, district attorney, parole, corrections, certainly judicial. And I think we've spent many years trying to figure out how to make that difference. And we thought making a difference was just the pure law enforcement protecting the public come hell or high water. I think that I would agree with the comments of all of the panelists. Evidence-based practices gets us kind of back to why we're here to begin with. And I think that, again, the proof is in the demonstration that it works. And I think for those judicial entities that are taking on evidence-based practices and can demonstrate the efficacy of them in the system, and that it really creates a coherent approach to managing this person with problems, I think that that's what will catch it on. I think that it's sometimes a hard sell for people who see their role in the system as, I'm here to sentence based on retribution, or I'm here to supervise and enforce conditions of parole, period. And I think that when we prove that it actually enhances public safety by applying these strategies, I think it catches on of its own volition.
Thank you. I think we have time for one more question with probably one short answer, Kate.
Thank you, Chief Justice Durham. And the final question will be, what challenges have you encountered as you've begun to implement evidence-based sentencing practices in your own jurisdictions, and how have you overcome them? What advice could you give to a jurisdiction just starting down this road?
Thank you. That's a good question because our panelists have tended to speak to very positive experiences and success. So what's been very hard to overcome, Judge Maurer?
I would say just what the other panelists have said, that is the viewpoints that are entrenched and are based on retribution. The way you have to do it, in my view, is you have to convene the partners in the system, and you have to talk with them regularly, and you have to have demonstrations, if necessary, where you can put up a PowerPoint that will track success, and that's the only way to do it. It's one person at a time, in a way.
Thank you. Mr. Bouch?
In some ways, it's like negotiating a labor contract. You have to bargain from the interests of the people. And sitting down and getting some very candid discussions about what is it that people are trying to protect with their resistance, where do they feel a threat, what do they need out of this new way of doing things to be able to become an equal partner. If in that process of that appreciative inquiry about what their motivations are, you end up getting to a place where you can find common ground. And it's first you take a small step and then a bigger step and then a bigger step as you prove that this is not the horrible thought, the tidal wave coming at them. Fear dissipates with familiarity.
Thank you. And Chairman McVeigh.
Well, I think we've all talked about the philosophy of people who have entrenched approaches to how they've always done their work, and I think that we do have to bring in new blood. I think we have to identify the people in the system who are willing to learn and learn to do their business differently, and then build on that foundation. That's what I've done here in Pennsylvania. I think another huge challenge is getting people to reinvest in systems. Justice reinvestment talks about taking money from correctional systems and putting them in community corrections and probation and parole. And, that's a big leap forward, but I think you have to finance what we're doing so that we can do it correctly. And I think a huge admonition that I would give to everybody is don't do it halfway. Oftentimes people attempt to apply evidence-based strategies and it sounds good on paper and they can talk like they're doing it, but when you do process evaluation, in fact, it's not being carried out consistent with how it needs to be to have the outcome. And if you don't implement it correctly, then your outcome's not going to be desired, as desired. So it's the carrying it out and implementation is critical. Better to start small and do it correctly than to try to take on too much and then let it fail.
Thank you so much for those responses. I need to begin to bring the webinar to a close.